Well, good afternoon, everyone. Or in the case of Dr. Dorset, probably good morning, a good early morning. Thank you very much indeed for cooperating in the presentation of this important appeal by way of a remote hearing. It does have its inconveniences, but our experience so far has been that on the whole, these remote hearings can be conducted entirely successfully. But if anyone experiences any problems of the hearing, please do let me know. There are two preliminary matters to be dealt with. The first is that Lady Black, in an earlier hearing in this case, granted an injunction, we believe, on an ex parte application, but having considered that and its possible relevance to the present proceedings, we are satisfied that it has no bearing whatever upon them. But in the interest of transparency and through probably what is an excess of caution, we draw that to the attention of the parties, unless they wish to make any comment upon it. The second point is in relation to the judgment of Mr. Justice Moore, as he now is. Apparently some paragraphs of his judgment are missing, and that's the judgment that he delivered while he was a deputy judge. And I am going to ask Lord Sales to draw the particular paragraphs to your attention so that you can give that some attention. Lord Sales.
Yes. Some of the paragraphs were simply misplaced, and one can find where they are. That's paragraphs 30 to 48. However, I couldn't find paragraphs 84 to 90. This is at page 32 in the electronic bundle, and it's really just a request. If they can be located and sent on to the board later on, we'd be grateful. Thank you.
Thank you. There is one final matter, and that is that after we've heard from Mr. Joseph, we will take a short break. We find that the successful though they are, do require perhaps a greater level of concentration than normal hearings. So we do tend to take a break halfway through, and at the end of Mr. Joseph's submissions, that seems to be an appropriate time. Now, Mr. Joseph.
Lord Kerr, thank you very, very much. And we are also very grateful to you for making the arrangements for doing this remotely. Lord Kerr, my lords, my lady, Mr. Joseph, I appear with Mr. Hugh Marshall for the appellant, Mr. Hugh Marshall of Hugh Marshall & Co., and Dr. Dorset appears for the respondent. The issues are as stated in the agreed statement of facts and issues, and likewise the salient facts. And in the interests of economy of time, and with your leave, I'm going to jump straight into the stated issues and to highlight certain matters which arise from the respondent's case, and also to deal with certain paragraphs of the Court of Appeal judgment. So if I could go straight into issue one, if I may.
Yes, of course.
So issue one is whether it is open to the respondent to bring summary registration proceedings under CPR 72 or the Reciprocal Enforcement of Judgments Act in Antigua and Barbuda for proceedings to enforce orders made in family proceedings for division of property on divorce, or whether they have to be brought by way of a separate common law action. And the appellant's case is clear and simple. The respondent must, in these circumstances, bring an action at common law and not by way of summary registration. CPR 72 of the Rules of Court of Antigua and Barbuda govern all inward summary registration proceedings under the Reciprocal Enforcement of Judgments Act. And it is common ground between the appellant and respondent, and indeed has been before the Court of Appeal and the Court of First Instance, that CPR 72 is not open to the respondent in this case. I just pause because I've lost the video link of Lord Kerr.
Yes, I think we had better pause for a moment. I'm not sure whether our technical support can see whether he's still online.
This is Jason from the broadcast team.
Yes.
I can see that he is in fact on the call. The concern is that he isn't responding to us vocally, because usually the audio is prioritized over the top of the video and he would still be able to interact. So if you please bear with us, let's hold it there for a second and we'll see what we can do.
Thank you.
I was just making the summary submission of the appellant in relation to issue 1. So I probably ought to go back there. I think that's where we lost you.
Yes.
So the respondent, the appellant's case is clear and simple. The respondent must bring an action at common law and not by way of summary registration. CPR 72, which we will look at very shortly, governs all inward summary registration proceedings under the Reciprocal Enforcement of Judgments Act. And it is common ground between the appellant and the respondent, and indeed was before the Court of Appeal and the Court of First Instance, that CPR 72 is not open to the respondent in this case. Lord Briggs.
Yes, can you just help me with why? Which say rules apply to all civil proceedings, not to family proceedings, or other proceedings instituted under an enactment insofar as rules made under that enactment regulate those proceedings. I'm on page 536, electronic. My question is, why, I assume the common ground is because everybody thinks that an application to enforce a foreign judgment in proceedings which that foreign jurisdiction calls family proceedings are themselves family proceedings. But I'm gently questioning why that should be so, yes, and why they're not proceedings under an enactment for which no specific rules are made.
Well, Lord Briggs, if I could answer this. So the first, to give you a couple of references in the Court of First Instance and the Court of Appeal, but then I will actually have to then go back to the first judgment of Mr. Justice Michel as well. So the judgment of Mr. Justice Henry at first instance, paragraph 24.
Do you have an electronic page for us?
Yes, I'll give you that. So that is at page 47. It's the first line. It's a very short paragraph.
I'm sorry, I misheard your page number.
47.
Oh, 47. Thank you. Yes, well, that, with great respect, doesn't tell me why. It records the court's view.
I apologize. I was first of all showing you the references as to where that was the position below and the Court of Appeal.
Well, I'm perfectly happy to take it from you that it's been common ground, but since this is an important point for the civil procedure or family procedure of this jurisdiction, I'm just anxious to know why.
Once a judgment is registered, under the Act, I will give you the reference. It takes effect as if it is a judgment of the Antiguan court in the proceedings. So, in other words, whatever the nature of the proceedings was in the incoming court, it is the same proceeding in the registered court. And so if you look at the Act, which you can see at page 67 of the record.
Thank you.
And if you look at page 69, which is section 3, sub 3, little a, the provision is that the judgment, once it is registered, takes exactly the same force and effect as if it had been a judgment originally obtained or entered in the High Court of Antigua. So the submission is whatever the nature of the proceedings was originally, it doesn't change merely because it's been registered that way.
Thank you.
Lord Leggatt.
However, this isn't a proceeding on the registered judgment. It's a proceeding seeking to register a judgment. So I'm not sure that section 3.3a is a complete answer to the point.
Well, the application is to register it, and once it's registered, it takes effect in that way.
Yes, but we're concerned with the procedure, or what procedural rules govern the process of registration, not any actions that may be taken after it has been registered, and if it can be.
Yes, but certainly the argument below in the Court of Appeal was that the nature of the proceedings does not, that the substantive nature of the proceedings does not change. It is always family proceedings. And it will then take effect as a judgment in family proceedings. To answer Lord Leggatt's point, the formality of how you get there is CPR 72. CPR 72 is the only route through which you get there. So I take the point, but I think it's a point in the appellant's favour, because the only way you can go from an incoming judgment to registration is through the 72 route. There is no other procedure.
Yep.
If I could give the board a further reference, this is also it's to the original judgment of Miss Justice Michelle, which is at page 367 of the record.
Yes.
Where the point that I'm making was in essence accepted by Mr. Justice Michelle at the first registration attempt. It's paragraph 17 for your reference. The nature of the proceedings doesn't change. There is a procedural route through CPR 72, but it's not open to them.
Yeah.
So with those references, I wanted to show my lady, my lords, a further rather important passage in the respondent's case, because this actually does frame quite neatly where we are at the moment. If you look at the respondent's case at paragraphs 11 and 12, so the rules of court are inapplicable to family proceedings. This is what the respondent says. This means that the rules of court, including CPR 72, cannot be resorted to in the prosecution of family proceedings. However, this does not mean that the limited scope of the CPR renders the Act inapplicable for the purpose of registering a judgment. whereby a sum of money is made payable. And then just dropping down a little bit, the absence of rules does not oust the jurisdiction. And then in bold, sorry, because an application cannot proceed by way of CPR 72 does not mean that an application cannot proceed at all. An application may be brought under the Act and not under the rules. And so really the difference between the parties under this issue is whether CPR 72 effectively is the means or the way in which summary registration is brought about. To paraphrase Lord Leggatt, we say it is, and it is the only way, and it's not open in this case for what is common ground to be family proceedings. If I could just then, with that introduction, just approach this in a little bit more detail. If we turn to the Act itself, which I think you have in the record at 406. I wanted then to turn to get straight to section 5, which we can find at page 409. So section 5, which is obviously of central importance to this appeal. A provision may be made by rules of court for regulating the practice and procedure, including scales of fees and evidence, in respect of proceedings of any kind under this Act. And the appellant's submission is really straightforward, which is when such rules are made, they do indeed govern the procedure in any proceedings of any kind under the Act. And this is clearly an application for registration of the Act, and the rules once made have statutory force. I just pause there. We have cited references in our case at paragraph 14, and that has not been responded to, so I think that can be taken. And what I probably at this stage should do is show my lady, my lords, the decision of the Privy Council in Quinn versus Press T. Con, which you will find in the authorities at tab 21. I don't know if your authorities are just paginated or tabbed. I don't know if I could ask that. I can read out page references, but I don't know if tabs would be helpful.
Well, I don't.
No.
Page reference
right. In that case, it is the decision. In that case, the decision is found at 1321, 1321 of your bundle.
Yes.
I'm so sorry. Yes, and yes, Quinn. This is Quinn.
What do you look at?
Yes, it's a very short passage, but it's not unhelpful because actually there are very few decisions of the Privy Council which relate to inward registration under the equivalent of the 1920 Act. And so if you look at page 1325, between letters B and C, the board, having recited the Trinidad and Tobago Ordinance, which is in essence in the same form as the Act that we're looking at, refers to section 8.1, which is the equivalent of Section 5 in our Act, and says that the Chief Justice, with the concurrence of a puisne judge, has the power to make comprehensive rules of court to govern the procedure to be followed in any proceedings taken pursuant to the ordinance. Rules so made are contained in Order 71 of the Trinidad courts, and the whole thrust of this decision is that once those rules are made, you apply the regime which is set out in the rules. Now, that was, it's not a point of complete unimportance in that case, because the application to register was made outside the 12-month period, but no application was made to extend time. And what the Privy Council held is that, well, you read the Act together with the rules, and the rules themselves didn't require an application to be made. And so the rules govern how such registration is to follow, and there is no requirement for an application to extend time to be made. So we say that Quinn is in our favour in the sense that once the rules are made, the rules actually do govern the procedure to be followed in any proceedings taken under the Act. My lady, Lady Black.
We've lost Lord Kerr again. I don't know if we've lost Lord Kerr again as the first. There he is. But the other thing was this. Okay. The other thing was this, Mr. Joseph, that I'm assuming that in Quinn, the rules that were made did cover the class of proceedings which were being litigated. See and contrast this situation where the rules don't. What difference does that make to the principles that we get?
And my lady, my answer is that the rules tell you what class or category of case can be the subject of summary registration.
Right. So it's back to the main point, really.
Yes.
The rules. If they're not there, you can't use the Act.
Yes, and it doesn't mean you're without a remedy, because of course you've got your common law action and so on.
Yeah. Could you just take us back, Joseph, to the rulemaking power?
Yes, of course. Which is Section 5, which you find at page 409 of the record.
Yeah. Yeah. And giving sales of evidence in respect to proceedings of any kind under this Act. That the rules, the type of proceedings that will be subject to the rule.
Without being cut. I'm sorry. So the expression, practice, and procedure would govern both the scope of the remedy for summary registration and how it is to be gone about. And if I could emphasize that just a bit further by reference to Section 2, subsection 2 of the Act, which you find at page 407 of the record.
Yes.
Which is subject to rules of court. Any of the powers conferred by this Act on any court may be exercised by a judge of the court. It is leaving open the possibility that the rules of court would make provision as to what type of proceedings would in fact be the subject of summary registration. Lord Legate. So it's, I'm just, yes, Lord Legate.
Isn't the short answer to your argument that provision hasn't been made by rules of court in respect to proceedings which are family proceedings? Because, as you said at the outset, CPR 72 doesn't cover family proceedings.
My response to that is no, that the rules have been made for a comprehensive code as to what can or cannot be registered through the summary registration process, and it doesn't cover family proceedings. So
but there's nothing that says that you can't read in the rules or in the Act that says you can't register a judgment in family proceedings. There simply isn't a practice and procedure provided for it.
No, there's a difference between the complete absence of a rule, and I'm going to come to two of those cases where there just isn't a rule, and where there's a rule which tells you that this isn't how you can do it. And those are conceptually two different things. We say not only is it clear from the Act and the rules, but it's also clear the way that the two prior cases which were relied upon by my learned friend were decided.
Thank you.
We rely both on section 2, subsection 2 and section 5. I think there's a degree of familiarity with the board of the provisions of CPR 72 and 2.2. But if I could just highlight the one particular provision in 70, or rather two particular provisions in CPR 72, which we find at page 942 of the record. And
yes.
The opening words of 72.1a we rely upon because in many ways this is an answer to what was put to me by Lord Legate. This is the comprehensive code which deals with the procedure for inward registration under the provisions of any enactment which allows such registration. And my learned friend relies upon the words in this part is subject to the requirements of any relevant enactment, which is 72.11c, but that's actually dealing with something different. That is because the Act, as you I'm sure are familiar with, under section 3, subsection 2, very similar to our 1920 Administration of Justice Act, has certain grounds on which registration would not take place if there's fraud, public policy, and so on and so forth, no submission to the jurisdiction. So the subject to the requirements of the relevant enactment are the safeguards in section 3, subsection 2, and likewise the time limit, which is expressed in section 3, subsection 1. But otherwise, CPR 72 is the code. It is the code. You either come within it or you don't for summary registration. And it's not a case which my learned friend I think would have it,
yes.
of rules impermissibly amending a statute, because the statute itself is expressed to be subject to the rules and expressly allows the provision of rules to be made to govern the practice and procedure, and I think I've already made that point. So really, my learned friend then comes to two cases in particular. Oh, sorry, Lady Blank.
I was just going to ask you how 72.1a on this analysis can have any effect with regard to family proceedings when they've already been put outside the scope of the CPR by 2.2.
Yeah, yes, lady. I mean, that really, in essence, is the appellant's case. It's common ground that none of 72 applies.
So how can 72.1a confine the ability of a family litigant to use the Act?
sorry, I come at it from the opposite end. 72(1)A tells you that this is the code for summary registration. This is the procedure. This is you either are in it or out, or there isn't such. This is the procedure. There's no other. And 2.2 tells you you're outside of it. That's really the nub of the point.
Okay.
Yes, you're late.
But isn't the point that 2.2 is logically prior to 72? That's my latest point, because it's dealing with the entire scope of the rules, including 72. You want to take 72 first, but you can't, because on your own case, 2.2 excises Rule 72 from family proceedings, and therefore you can't have it both ways.
Well, I do apologize if it sounds like I'm trying to have it both ways. I'm only trying to have it one way, which is that that there is only one code for registration, and that code is section CPR 72.
But it's part of the rules.
I'm so sorry?
It's part of the rules.
Yeah, it is part. It is 72, which is part of the rules.
Yeah, and those rules don't apply in this case.
Correct. And so there is, in essence, a code. Rules have been made, but they are rules which exclude the family proceedings of which we're engaging.
Yep.
I deal then very briefly, if I may, with the two principal cases my learned friend relies upon. One being the Port of Contractors versus Shipping Association of Trinidad case. That I think you will find in the record at 1338. And this concerned powers of joinder of an industrial court that had very wide powers to regulate its own procedure. I hope I don't need to take you to that passage, but for your record, it's at page 1341 of the record at letter H that the court had those wide powers. The point here is at letter F at page 1342, which is to the effect that there was no rulemaking authority created, and no indication was given as to how it should constitute itself into such a rulemaking authority. And so no rules were promulgated, and the Court of Appeal in the Port of Contractors case said that therefore they still had the wide powers to regulate the procedure themselves under the Act in relation to joinder. So we say that's a distinguishing case because, of course, there is no equivalent of CPR 72 governing the subject matter. Now, my learned friend, I think, recites in his skeleton a passage at page 1343, which is that the Act can't be construed, that is our Act, as having a condition precedent that a code would be created in order for there to be an exercise of a power. But that, we say with respect, misses the point, because this is not a case where no code has been created. We have a code, it just doesn't apply to family proceedings. Now, a very similar point arises out of the Attorney General of Ontario and Daly case in the Privy Council. That is a case which you can find in the record at 1025. And I don't need to say very much about this, except that the issue there is whether the Supreme Court of Ontario had jurisdiction to issue a mandamus to require a judge of the criminal courts to try a person accused under grand jury indictment. But there were no relevant rules of court. As we have pointed out in our case at paragraph 20, that is again another case where no rules of court were made, and that is made clear in a passage from Viscount Cave at the top of 1029 of the record. And so if I could just ask you to mark that, I don't think it's disputed, but this is a case where no rules regulating the method in which the power of mandamus is exercised has been made. And that circumstance did not prevent the Supreme Court from making full use of its powers. So this is a slightly different case to those cited by the Court of Appeal, where a code has been issued. It was the Act itself expressly said it's subject to the rules, and that rules may be provided for. They're provided for, but they don't provide for registration of family proceedings. So that probably is all I needed to say on issue 1. Issue 2 is obviously, if you're with me on issue 1, then issue 2 doesn't arise. It just simply falls away. But issue 2, which was in fact dealt with by the Court of Appeal in essence as part of issue 1, but they're quite separate points, which is whether orders for division of matrimonial property or periodical payment orders fall outside of the 1920 Act regime in any event. And the appellant's case is, again, I hope, clear and simple, that yes, they do, because the Act only applies. Sorry, Lord Legger. I can't.
Sorry, I don't understand this issue, because this isn't a periodical payment order, unless I missed something. It's simply a judgment for payment of a lump sum of money.
You're right.
Squarely within section 2.
You're right about periodical payments, but this is an order for the division of matrimonial assets, which I will show you was dealt with both by transfer of property and payment of money.
Well, there might once have been such an order, but the one being registered is simply for payment of money and nothing else.
Well, I think I may have to show, my lord, the order itself, because it's a bit different to that. We would respectfully submit, but perhaps I can show you the order in 2 moments. But could I just can I just say what the headline point is, as it were, and then hopefully make it good in relation to the orders themselves. But the headline point is that the Act, according to the appellant's case, is that that this is exactly the same position at common law, that it would only apply to the registration of what Lord Herschel described as a final and conclusive judgment, and not something which can be either adjusted or which does not extinguish the cause of action. That was the position at common law, and we say that the Act has not changed that. And indeed, we are a little fortified in that, because the Court of Appeal's approach, as to which there's no challenge, as it were, from the respondent, is that this is an Act intended to reinforce or fortify the position at common law. So could I just very, very quickly take you to Lord Herschel said in the Nuvian and Freeman case. Yes, Lady Black.
Just as the background to this, as a matter of fact, is this the point that you lost in front of Mr. Justice Michel? I think paragraph 18 of that.
So just forgive me 2 seconds. I'll Are you looking at page 368 of the record?
I am.
Yeah,
I am.
Yes, I think that the way that went in front of Mr. Justice Michel is that he was open to the view that the sum of money then, which was 3.1 million, is now 1.8 million, could be registered under the Act. But of course, the registration itself was dismissed.
Yeah, so it is the point you lost.
I think it is in that area, although it's not. It's a bit condensed, those few lines. But if I could just take you very, very quickly to the House of Lords in Nuvian and Freeman. I think it's a well-known decision, but it's in the record at 1303. These were the rules circumscribing the circumstances in which an action could be brought in this country, the United Kingdom, on a foreign judgment for the recovery of a debt. In that case, the House of Lords, and it's Lord Herschel's speech in particular, held that you could not, if the judgment did not finally and conclusively settle the existence of the debt, so as to become res judicata between the parties. And if I could just take you to this two very short passages in Lord Herschel's speech, the first being at the bottom of page 8 of the judgment, that's 1310 of the record.
Yes.
What is said here is, after reliance on Baron Parker and Baron Alderson and Williams and Jones, which stated the law as such, where a court of competent jurisdiction has adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum, on which an action of debt to enforce the judgment may be maintained. But it was conceded, and necessarily conceded by the learned counsel for the appellant, that a judgment to come within the terms of the law as properly laid down must be a judgment which results from an adjudication of a court of competent jurisdiction, such judgment being final and conclusive. And the further passage, which is relevant to what I'm going to show you just very, very shortly, is at page 11 of the judgment at the speech at 1313 of the record. And it is the second paragraph. My lords, the plaintiff in such a suit, an executive suit, is not by the decision which is now under appeal deprived of his rights. He may still sue upon the original course of action. And that may be barred by lapse of time, but that's an accident. The right of the plaintiff to sue on his original course of action is not interfered with by the judgment which has been pronounced. So with that guidance, I wanted to show you why, contrary to what I think my Lord Legate was saying, that these are not final conclusive orders, but they're subject to adjustment, and the original cause of action has not been extinguished. So if I could show you that now. So the December 2009 order, which is the foundation order, which from which everything follows. Yes, my Lord Lawbriggs.
Of action in the context of a judgment obtained in England in family proceedings pursuant to a statute which has no application, as far as I know, in this jurisdiction. And the difficulty with trying to fit these common law concepts into a judgment for a sum of money in English family proceedings is they don't really proceed on the basis of a cause of action, as I understand it. They proceed on the basis of a statutory regime.
My Lord Lawbriggs, I think that what I will show you is that that's actually an important point, because there's a statutory cause of action under the Matrimonial Causes Act, which is itself not extinguished.
But you couldn't sue on that outside the UK, could you?
No, so I think that for present purposes, if you forgive me, for present purposes, what we're examining is whether or not there has been a final adjudication from the incoming court, because it would not then otherwise be registrable. It would not be, you couldn't sue on it as on the common law, and you couldn't register it either.
Okay, thank you.
So the order which we need to look at, which starts all this off, is the December 2009 order, which is found at page 357. I'll just wait a second. I'll just wait. Sorry.
Just would like to know, as we start to look at this, what you say isn't final about this order.
There are two things. First of all, the sums are to be adjusted by reference to certain transfers of property. That's the first point. And the second point is that until the monies are finally discharged, the original cause of action under statute of matrimonial causes action, matrimonial causes act is not extinguished.
Okay.
Those are the 2 points. So if we get to page 357, this is the 2 points really that I wanted to highlight. Was that if you look at paragraph 2, paragraph 2 of the order says the respondent must pay to the applicant a lump sum of 4.1 million by not later than the 21st of December. And then there are rather complex provisions, what happens in default of compliance. And those provisions relate to certain trust funds, transfer of a beneficial interest in a life bond, and so on. And we know, of course, that the monies were not paid by that date. And so those provisions then effectively kicked in, which ultimately led to a continual adjustment of the sums from 4.1 million down to the present sum that we're engaged in, which is 1.8 million. But if I could also take you to paragraph 8 of the order, which is we would submit also important, which is upon implementation of the full terms of this order, including the payment of any interest arising from the late payment of a lump sum, the petitioner's claims against the respondent for financial provision, whether of an income or capital nature arising from the dissolution of marriage, shall stand dismissed, and she shall not be entitled to make any claim. And then there's reference to both the Matrimonial Causes Act that I mentioned earlier, and also the Inheritance Act of 1975. So we would submit that not only is this not a final sum which is not further adjusted, but until the payment of that sum, the original statutory cause of action is not extinguished. And we say that that's not only does that take it outside the Act, actually it is a defence to an action at common law as well, for the reasons that Lord Herschel gave. Now, just I can take the history of this through very, very quickly. If you look at page 361, which is the May order, this is not a standalone order, as I think Mr. Justice Michel would have had it, but it is expressed to be pursuant to paragraph 2 of Mr. Philip Moore, as he was then deputy judge, his order of the 7th of December 2009. And so it is adjusted down through the implementation of further provisions for the transfer of property and so on. And then that was carried through, we can see, into the July order, which is where we are now. And that is at pages 377 to 378. So paragraph 1 is a at page 377, a discharge of the money judgment order of the 10th of May, which we've just looked at. But paragraph 2 is important, which is the attached money judgment order is made setting out the monies due and owing under the financial remedy order of the 7th of December 2009. So this is a further adjustment down to 1.8 million. But yet again, paragraph 8 of the original order still stands, and we say that that has the effect of not extinguishing the original cause of action as per the Lord Herschel reasoning. Now, there's not very much to be said about all of this in the Court of Appeal's reasoning. If I could perhaps just give you the reference in view of the shortage of time, but at their Court of Appeal judgment at paragraph 32, with respect to the Court of Appeal, I think they went down a slightly wrong road by referring to what it was undoubtedly a strong Court of Appeal in Beattie and Beattie. That is not in dispute. But the Beattie and Beattie, in fact, turned on the difference between the common law position in England and the position that that prevailed in the United States of America, pursuant to a case called Sistare and Sistare that we don't need to look at. But the position in Beattie and Beattie is exactly in line with what Lord Herschel said in the Nuvian case. And so we would say with respect that the reasoning of the Court of Appeal at paragraph 32 does not withstand scrutiny. We have gone through all of this in the appellant's case at paragraph 27, if I can give you that reference, but there's been no response by the respondents to that. So the only 2 points then that the respondent has taken is as follows: that the July 2012 order that I just showed you for 1.8 million is a standalone order for the payment of a sum of money, but with respect, that can't be right because its very terms refer to an amendment of the December 2009 order. And I've given you those references already. And the second point that the respondent takes is that we are seeking to override the wide definition of judgment in the section 2 of the Act, but that's with respect not right. The word judgment is always read in the same way as a judgment or an order for the payment of monies was understood at common law, and indeed when the Court of Appeal tracked through the history of the Act, they said it was to render easier the enforcement of judgments which were enforceable at common law. So that's probably all I needed to. Sorry, Lord Legate. Yes.
But is there authority which says that judgment in the Act must bear the same meaning as at common law? Because obviously it does render it easier to enforce judgments if you don't have these what may seem artificial restrictions.
Well, if I could perhaps attack that in with 2 answers. The first is this: that that this Act, which is the Antigua Act, does not just come out of nowhere. It is to mirror the provisions of the Administration of Justice Act of 1920. And what the Court of Appeal did, which I think is not disputed, is to track through the history of the 1920 Act by reference to some of the passages in Owens and Bracco, which if one could track back, but certainly the Owens and Bracco decision is, we say, good authority for the proposition that the purpose of the AJA, if I can just shorten it, was to render more have a summary process for enforcement, that which was enforceable at common law. The second point I was going to make to Lord Legate is this: that it may be that some of us have had experience of the wider provisions under what is now the Brussels recast, and certainly was the Brussels Convention going back some time. but they have a broader meaning and understanding of the enforceability of an order. That can be an interlocutory order. It can be an order for anything. It can be an injunction. It can be absolutely anything. And that is not the regime that was put in place in relation to the administration of justice.
Thank you.
So if I could come then, albeit quite briefly, to the two further issues which are before us. The first is this: it is the issue estoppel and abuse of process, which is, if I could conveniently try to take issues 3 and 4 together, hopefully I can be quite brief on this. The question is whether there is an issue estoppel or an abuse of process arising out of the relitigation of the attempt to register previously orders made in these same proceedings under CPR 72. That's the question. It really follows from the decision of Mr. Justice Michel way back. I seem to remember quite some time ago in 2011. But it comes out of that decision where he says that the CPR 72 route is not open. That is not appealed, and there is we say this is covered not by the guidance given by Lord Sumption in Virgin Atlantic in relation to cause of action estoppel, but rather in relation to the guidance given, we say, in our setting out the references in our case to issue estoppel, and particularly the speech of Lord Guest in the Carl Zeiss case, which you're all familiar with. If you wanted to have the reference for your note, it's in particular Lord Guest at 934 to 935 in the reported decision of the Carl Zeiss case. The issue that arose there is, we say, of direct relevance to what is now before this court as to whether or not there's a CPR 72 route open to the respondent, and we say there is no such route, and we should not be vexed twice by the same issue, and that actually what in fact should happen is very much as anticipated in the Act itself, which is if registration fails, it is anticipated that you would then proceed by way of a common law action. There is a reference, it is slightly oblique, but it's, I think, understandable, which is if you go back to the Act, which was at 406 of the record, and turn to section 3, subsection 5, which is at page 409.
Yes.
Which is that what the Act provides for is, in an action brought in the Court of Antigua and Barbuda on any judgment which might be ordered to be registered under this section, the plaintiff shall not be entitled to recover any costs of the action unless an application to register the judgment under this section has previously been refused, or unless the court otherwise orders. In essence, through the sanction of costs, this provision is directing the parties first to try through the registration process, and not to go first to an action on common law. But if you have had your registration refused, the implication is here that the logical route is to go straight to the common law action on the judgment. There's not much to say, in fact, in the respondent's case on this, apart from their setting out in quite a lot of detail principles of cause of action estoppel. In paragraph 23, sub 4, at page of their case at page 329 of the record, the respondent is, I think, saying that there can't be a cause of action estoppel because the proceedings is not based on a cause of action. But we say that's a non-point because issues arose in the first registration, which are governed by the principles of issue estoppel. In paragraph 5, again, they're seeking to limit the principles of Henderson and Henderson to cases where a claim has been brought, but Henderson and Henderson applies equally to issue estoppel as it does to a course of action estoppel, subject to safeguards, obviously. And then the last point that I probably needed to cover is the implication, which is at subparagraph 6 at page 330, 330 of the record, that we are faced with concurrent findings of fact of no abusive process. And that we say is not right. Mrs. Justice Henry, in fact, made, sorry, I apologize.
Before we move to abusive process, on issue estoppel, Mr. Joseph, it's a general principle of issue estoppel that to give rise to it, the point has to be necessary to the determination. And one way of testing that is whether there could have been an appeal on the point. You've made the argument that no appeal was made, but what do you say to the point there couldn't have been an appeal because they lost separately because they brought an ex parte application? That was they lost for that reason, and any appeal would have been bound to fail for that reason. So this point wasn't fundamental to, or essential to the decision, and indeed they couldn't have gone to the Court of Appeal on it.
Yes, well, if I understood the argument below, I think they were not accepting that it was made without notice. I don't know. I don't think they were accepting that that was the position below.
Well, they may not, but are you saying that the judge was wrong on that point?
But I mean, I'm not sure it's necessary for me to say that the judge was wrong on that point. I mean, I take my lord's point, which is that if you lose on more than one basis, then it may not be necessary. It's the direction of the judgment though was this failed in limine because it was not it was family proceedings and it was knocked out. And if they wanted to resist that, they should have appealed that. That's what we say.
All right, one other question. Was the point about the scope of the act decided in that case, or was it just put on the basis of the scope of the rules? Because at least the argument was put, as appears from the judgment, was that they said that they could get in under the rules because these weren't family proceedings.
Yes, I mean, I think that the primary way it was put was in relation to the CPR 72 point. I take my Lady Black's point, which I don't think I don't think I'd focused hugely on paragraph 18, but it does look as though there's a reference. I have to concede that it does look as though there's a reference in paragraph 18, which I don't think I paid that much attention to. It's quite short about a sum of money being payable and so on. I don't know if that was squarely argued before.
But on 17, on paragraph 17, the argument being made is it isn't family proceedings.
Yes.
And that seems to be the fundamental basis on which they lost, apart from the ex parte basis.
Yes, I mean,
that's not the argument now.
That's how we put our issue estoppel. The fundamental basis on which they put it was that these were that notwithstanding they were fact that this was they said these aren't really family proceedings, and they lost on that point. And
yeah, but that's a different issue from the one now being argued.
Well,
it's accepted, as you showed us right at the beginning, that these are family proceedings.
yes, that is right, and I can see the direction of this at this point. I'll take it quite shortly. I think that in essence, they can't row back from whatever was decided here at paragraph 17. They can't now suddenly change tune, as it were, and say that notwithstanding the family proceedings, they can still come within the rubric of the rules.
Thank you.
So I don't think I need to take much further time in relation to concurrent findings of fact, because I've only got a few more moments to deal with the last point, which is quite important too. But in relation to concurrent findings, if I could just give you this reference, there wasn't actually any finding of fact by Mr. Justice Henry at first instance. That is found at the record at page 47. And in relation to this point, all she finds at paragraph 25, the very bottom of the page, is one sentence, which is a legal finding that the issue of abusive process doesn't arise since the order sought to be registered differs from the one before Michelle J. So there's no concurrent finding of fact. She's just made she's made a determination as to what issues arise and so on and so forth. And I think that the board will just have to take a view on that. My lady, my lords, if with your permission, I've got about 10 minutes left, I think, on the clock, and according to our agreed division of time, and I'd quite like to deal with the last of the issues, if that's at all possible, and that relates to the separate point in relation to the default costs order. I'm very grateful.
Of course, and to the Joseph, since we, because of the failure of our internet in your submission, we'll be fairly relaxed about allowing a little extra time to complete your submission.
I'm very grateful for that. So this relates to the registration of the default costs judgment of November 2010. So first of all, I'll show you the order itself, which is the subject of the registration. And that's found at page 379 of the record. This is manifestly the costs order which was made in the same proceedings. If you look at the claim number at the top right hand corner, ending in 0763, this is the same claim that you see in relation to the 1.88 million on the previous page of your record at 378. This is the costs order in the same proceedings. Yeah. The first point that the respondents seek to take is that this is somehow a standalone order. It is not. It is an order made in the same family proceedings that we examined in relation to the first issue. It cannot be registered for the same issues, for the same grounds as we explored under issue number 1. And so we say that the registration, both of the claim for 592,000 and the 1.88 million that I showed you earlier, fail for the same reasons under issue 1. Now, that was certainly how we put it in our appellant's case. That has not been responded to by the respondent in its case as to how they say it is somehow a standalone order. But the point does not end there, because this is somewhat procedurally complicated. Because what happened was this: the order is made on the 12th of November 2010. You can see that date in the top right-hand corner at page 379. Uh, 12, 11, 10.
Yes.
Rather nice sequence of numbers. But the application was only made in July 2013, 2.5 years later. And you can see that from page 370. And that's, sorry, I apologize. I said July. I should have said June 2013. And that was 1.5 years after the 12-month time limit in the Act. Now, the main ground of appeal here is that the Court of Appeal erred because it should have applied the principles in Tambu Ratnam, a decision of the Privy Council, which I would just like to take you to. So if you turn to your authorities bundle now at 1349.
Yes.
Now, I don't think we are necessarily that engaged with the particular facts of this case, but it is the principle which is expressed at page 1349, 1, 2, 3, 4, 5, 6 paragraphs down the page that I wanted to draw your attention to. So, or I should say paragraphs 5 and 6. The principles upon which a court will act in reviewing the discretion exercised by a lower court are well settled. There's a presumption that the judge has rightly exercised discretion. The court will not interfere unless it is clearly satisfied that discretion has been exercised on a wrong principle and it should have been exercised in a contrary way, or there's been a miscarriage of justice. And then this sentence here: the rules of court must prima facie be obeyed. And in order to justify a court extending the time during which some step in procedure requires to be taken, there must be some material upon which the court can exercise its discretion. Now, what in fact happened here is that the respondent made no application for the extension of time, first point. Second, put no material before the court on which it could exercise such a discretion. The only point that it made was reliance on the Privy Council decision in the Quinn case that we referred to shortly previously, and I have to take you back to, which I would respectfully submit works against them. But they said that their answer was, we don't have to make an application, see the Quinn case. But there was no material upon which a court could exercise a discretion to extend time by 1.5 years. Now, we know from a general principle that time limits are generally to be complied with. Sometimes people are late by a matter of days and so on and so forth, or maybe even months, but 1.5 years is a very significant period of time compared to the 12 months, which is referred to in the Act. And if you were to seek an extension beyond that, you'd have to put some material upon which a court could exercise such discretion, and they didn't do so. So we say that there was an error of principle which allows the board to look again at what the position is. If I could just take you very quickly to the Quinn case and explain where we go next. So the Quinn case is again back at 1321 of the record. The decision in Quinn was in fact a decision which finally lands up, we say, against the respondent. Because if you look at page 1327, which is the last page of the report, by the way, the extension time there was 5 days. So 5 days.
Yes.
And the point was that the party seeking the extension of time said, I don't have to apply for an extension because Order 71, which is our equivalent of our 72, governs, and Order 71 does not actually require you to make an application. And so we say that this, in fact, works against the respondent because they can't have it both ways. Either 72 is the regime which governs all registration, in which case they're outside of it, we win on issue 1. But if 72 is not the governing procedure, then general principles would require a party who seeks an extension to make an application and put material before the court. And Quinn is not authority for the proposition that you don't have to put any material before the court. The point is, it was an extension of 5 days, and it was considered to be a sort of a de minimis type thing. But you couldn't possibly say 1.5 years is de minimis in this kind of case. So the only point then I wanted to further deal with is that the Court of Appeal concluded that no conceivable prejudice could have come to the appellant for the grant of an extension of time. That's paragraph 45 of the Court of Appeal. I don't think we need to look it up. It's just what they said. But now we need to go back and look at some of the dates, because with great respect to the Court of Appeal, that just simply isn't correct. If you remember, the costs order was made in November 2010. And the extension was granted on the 21st of November 2017, which is the date of the Court of Appeal's judgment. And even if you wanted to go back to the hearing itself, because there's no application, it was just simply, can we please register this judgment, the costs, please. So the hearing was the February 2017, the judgment was the November 2017. On either event, by that time, an action on common law on the order would have become time barred because of section 26 of the Limitation Act. Now, can I just quickly show you that? That's in the record at page 397. And that's, if you have that section 26 sub 1, an action shall not be brought on any judgment after the expiration of 6 years from the date on which the judgment became enforceable.
Could you give me the page number again?
397, my lord.
Yes.
So in very short summary, the extension was granted first without an application having been made on a wrong principle, because Quinn only governed where the CPR governs, 2, without any material being put before them as to why they're 1.5 years late, and we say the Tambu case governs in relation to that. And 3, the finding that there's no conceivable prejudice cannot be supported, because by that time there was in fact a 6-year time limit in relation to the underlying costs order. So we say that this is quite obviously completely independent of the first and rather interesting debate we were having in relation to the scope of family proceedings, but this is completely independent of that. Yes, my lord.
Was the time point taken in the Court of Appeal? The limitation point?
My recollection, and my lord, I have to be a bit careful here, because we did not put in a skeleton, I don't think, in relation to the time, in relation to the extension of time. It was the respondent put in a further skeleton, which is in the bundle.
But your client was represented in this.
Yes, but represented by me. I argued it, and I'm pretty sure we mentioned it, but I can't give sworn testimony. It is a few years ago, but I'm pretty sure we did.
Thank you,
my lord, Lord Sales.
Yes, I'm not sure that I'm following the time limit point. Section 26 says action shall not be brought upon any judgment 6 years from the date on which it becomes enforceable. In Antigua, the judgment would only become enforceable once registered, wouldn't it? And it's only registered by the Court of Appeal, as I understand it. So I'm just, it's probably my fault, but I'm not quite following why the time limit is irrelevant this year.
Well, because my lord, the way I look at it is different. This is an action to enforce a judgment. Which judgment? It happens to be a judgment of the English court. How is that being done? It is done through the procedure of summary registration. So summary registration is if you will, an alternative, a proxy for an action on a judgment. So the expression an action on a judgment must encompass a procedure which is the statutory equivalent of an action on a judgment.
Right, thank you.
My lord.
I thought your point was slightly different, Mr. Joseph, which is that if they hadn't pursued it through registration, they could have brought a common law action on a judgment. But that time bar for that expired after 6 years, and therefore they were prejudiced in being let in to the registration process. But have I got that wrong?
No, you haven't got that wrong. What should have happened? What should have happened is after the judgment of Mr. Michel, they should have proceeded through the common law action. But they've been let in, as it were, to use your expression. They've been let in on something that they would not otherwise been able to do.
Right.
Yes.
They've been given another chance, as it were, by the extension.
But your analogy of registration being a kind of proxy for enforcement, once you apply for registration, time stops running against you. The fact that it takes another 5 years before the matter is finally determined in your favour in the Court of Appeal surely doesn't feature in the running of time. And I think you said that this application was made, was it 2.5 years after the costs order was made?
Yes. I mean, the short. I mean, I think we may be going around in circles here, but the first point is, if you're 1.5 years late, you have to put some material before the court, which would explain why you're 1.5 years late. It's a huge extension of time, which would not otherwise be granted. But it's wrong to say that the application itself, just to correct you, my Lord Briggs, the application itself was not made in the way that you have quite expressed it. Can I show you the application itself?
Yeah.
So the application is at page 370 to 371. So there's no application for an extension of time, which would, as it were, stop the clock. It's simply, what happened is that they put in an application in 2013, 1.5 years late. And Mrs. Justice Henry, we say completely rightly, threw it out. Said, well, you know, you're way late. There's no application, no reasons. And then when they get to the Court of Appeal, that's allowed in, albeit beyond the 6 years, on the basis that that Quinn says, pursuant to CPR 672, you don't need an application.
Yes. So if Quinn's right on that point, I think your materials point is quite separate. In fact, they made their application, which didn't require it to be a double-barreled application, i.e. an application plus an application for an extent of time, 2.5 years after they obtained their default cost order, not more than 6 years after. True it is that by the time the Court of Appeal came to re-exercise the discretion, but that was on an appeal from a refusal by Justice Henry.
Yeah. I do take my Lord's point. I mean, I think that, and I'm not going to go round and round in circles here, but the just to come back on the Quinn point, obviously you can't have it both ways. Either 72 applies or it doesn't apply, and so you can't rely on 72 when you want to say that that no application needs to be made, but then disavow 72 when it's being said that you're outside its reach.
Thank you.
Right, Mr. Joseph, where are we now?
Thank you very much. My lady, my lords, I think I've probably used such extended leeway as I possibly could, and I'm very, very grateful to all of you.
Now, you did tell us that you appeared with Mr. Marshall. I don't know whether Mr. Marshall wishes to or is in a position to. No, thank you very much, everyone. Dr. Dort, we have had a preliminary discussion about the case, and we're required to hear from you only on the costs issue. And you can find your submissions to that, please.
Well, thank you, my lord. As to ground 5 of the case between the parties, I have addressed that, my lord, at page 331 of the record. My submissions, the respondent's case, begin at page 323, but the point on the cost order is to be addressed at page 331. As I understand the appellant's case, is that there is a 1-year period in which to seek to register a judgment. With respect, we disagree with that assertion if that is the case being made on behalf of the appellant. I draw the court's attention to page 407 of the record, which contains section 3.1. Section 3.1 of the Reciprocal Enforcement of Judgments Act.
Yes.
I draw this to the court's attention to answer the point as to what is the time period for the registration of a judgment. It reads, where a judgment has been obtained in the High Court of England or Northern Ireland or in the Court of Session in Scotland, the judgment creditor may apply to the High Court at any time within 12 months after the date of the judgment or such longer period as may be allowed by the court to have the judgment registered in the High Court and any such application the court may, if the circumstances of the case they think just and convenient, the judgment should be enforced in Antigua and Barbuda. So when you look at what is stated there in section 3, subsection 1, there is not a strict cut-off period of 1 year. It is you may apply within 12 months or such longer period as may be allowed. The fact is that the Court of Appeal allowed a longer period. So the registration of the cost order was not contrary to the statute, nor any principle governing the application of the statute. We would also say, my Lord, that with respect to the material that was before the court, in respect of the application to register both the, what I call the substantive order and the cost order, the court can look at the application, which is to be found at page 370 of the record. It begins there. And you notice, my Lord, that the application at 370 asks for 2 orders. Item 1 being what I call the substantive order, and item 2, which is the focus here, is the order for the cost order of £592,000. The material before the court is contained in the affidavit of Mrs. Tizina Bailey, which is in support of the application. So it is not a case where there was no material before the court. The material before the court is contained in the affidavit that extends from page 373 to 375, which is 3 pages of material, to which is attached the relevant exhibits. And the general thrust of the affidavit is this. There are 2 orders. All of the orders, both of them, arise out of the same matter. And because both orders, including the cost order, arise out of the same matter or the same case, it is just and convenient that both orders, including the cost order, be so registered. And so I would say, my Lord, that, and I make good that point, my Lord, if you look at paragraph 5 of the affidavit, paragraph 5 of the affidavit at page 374 of the record, it speaks to that point where Mrs. Bailey says, the order of 9th July 2012 is a substantive order and one given pursuant to financial remedy order dated 7th December 2009. Having obtained the substantive order of 9th July 2012, it is just and convenient that both the substantive order and the order for cost granted earlier be registered and enforced. So with respect, I think that the objections, as I understand it, coming from my learned friend, that the respondent was out of time. She was not out of time because the statute clearly says is as may be allowed. And certainly there was material before the court upon which it could exercise its discretion. And further, as the case of Quinn indicates, that one has to look generally at what is the purpose of the Reciprocal Enforcement Judgments Act. and it is to facilitate where you obtain an order in one jurisdiction, in this case, the United Kingdom, that you should be able to enforce it in Antigua once it has been registered under the Act. My Lord, I don't know if there is much more that I can or should say on that point, but I don't want to step beyond the liberty that has been granted to me. But that really is the case of the respondent on that point, what to do with the court order.
Issue.
Just very need to can you hear me? Very grateful.
Yes,
so just very just very briefly, if I may, just to say this, the statute clearly does provide a time period beyond which grounds have to be shown. That period is 12 months, and if you go beyond that, then you'll have to put some material before the court, which would enable the court to exercise that discretion. As regards the affidavit which was filed, there is no reason put forward at all. It is simply gives the dates on which the orders were made and asks them to be registered. No reason is given, and nothing is said as to why the delay has taken place, and so no reasons whatever are given. And the last point, of course, in relation to Quinn, we've already discussed this, but you can't both rely upon the basis on which Quinn was decided under the CPR 72, and then also then say that CPR 72 has no application in the present case.
Thank you very much. The board is very grateful to counsel for the and of course to those who assisted counsel and who did not participate in the proceedings. We will take time to consider what that they would humbly tender to Majesty and call this adjourned.
Very great.
Thank you.